So I am a proud graduate of Hillsdale College in Hillsdale, Michigan, founded in 1844, the first college in the United States to prohibit in its charter any discrimination based on race, religion, or sex. It was the second college in the entire United States to grant four-year degrees to women. And so I rise in opposition to this amendment, but I do so for a variety of reasons. Some have been stated by other speakers. Yes, I do have concerns regarding the abortion concerns, and I think those are valid points, but I have other concerns I'd like to bring up as well. First of all, Leader Lang, I was in that 4 hour, we went for about 3 or 4 hours in that subject matter hearing in Chicago, and you stated several times in that testimony, and then here as well on the floor, we need to add women to the Constitution. This amendment doesn't. It does not add the word women. It does not add women to the Constitution. Take a look at the language. It just says equality of rights. This comment has been made that we've had an ERA provision in our Illinois state constitution, and there have been none of these consequences that some on our side have raised, or some on your side have raised. But the language is different. Now, I'm not a lawyer, but I know that words matter. And the language in the amendment you have here, equality of rights, is different than what we have in our state constitution that guarantees equal protection under the law. Now, I've tried to do my homework, listen to what proponents have said. I'm looking at a flyer here from a group called Equal Means Equal. And I think this is what Representative Flowers was alluding to, that we are different. We are objectively different. That doesn't mean that we should have different rights. It just means that the law recognizes the differences between men and women, and those are reasonable, understandable, common sense differences, and we see that reflected in our federal and state laws. But according to this flyer, it says the ERA provides a fundamental legal remedy against sex discrimination for both women and men. The problem is, as we have seen in the last several years, that there will be men who will claim discrimination for not being able to participate on certain women's sports teams or receive certain scholarships that have been set aside for actual women. And if you have the hammer of the ERA, that those protections would go away, those protections for women. Furthermore, according to this flyer, the ERA would require the courts to judge sex discrimination with the highest constitutional protection of strict scrutiny, now used for religion and race. So we had a bill not long ago, now a law, now being challenged in the courts on the health care right of conscience. There are doctors and nurses, medical professionals, both men and women, who for reasons of conscience, do not want to be involved in the decision of abortion. Well, the law doesn't require them to do that. But with an ERA, it could be argued in court that those individuals are discriminating against a procedure that only women would be seeking. And so imagine a situation, just like we would find it abhorrent that someone would not provide medical care for someone of a certain race or a certain religion. Will a doctor or a nurse who has pro-life convictions be charged with discrimination and lose their license because they're discriminating against women for not wanting to do that procedure? I'm going to wrap up here. Just reading in the record some of the information from the Stop ERA group. And by the way, it's almost all women who are in this group. Women and men are biologically different. We must retain the ability to legally provide for these differences. We have a women and minority-owned business enterprise provision. Those would go away because that is a set-aside for women. In the 18 states that passed an equal rights amendment, there have not been benefits for women. Instead, the courts have taken away those protections. In Maryland, the court held that the state ERA, a husband could no longer be required to support his dependent wife. In Pennsylvania, a father was exempted from providing support for his minor children, and a husband's legal responsibility for his wife's hospital and medical bills was nullified. And finally, think about insurance rates. They're set based upon the differences in sex. for health, life, but also things like automobile insurance. Women are typically better drivers. They would not be able to get preferred rates because we will have equal rights.
Please make your final comment, Representative.
No differences based on sex. I needed another minute and a half if someone would yield their time to me.
Representative Barb Wheeler would like to yield her time to Representative Morrison.
Thank you. The last couple things I want to say is, one of my colleagues cited the number of states that passed ERA, and he cited conservative states, But keep in mind, when the ERA was first introduced in 1972, there were quickly about 20 states that ratified it. In 1973, there were another a dozen, maybe 15 states that quickly ratified it. Well, what else happened in 1973? The Supreme Court handed down Roe versus Wade. And that's why the movement on ERA dramatically slowed down, and it stopped. And actually, there were 5 states that have tried to rescind their ratification of ERA. That should tell us something. The timing of this, 1972, 1973, should tell us something, that our concerns about this being an expansion of abortion are valid. A constriction of reasonable common sense regulations about abortion are valid. The last I'll say is, there have been very strong, capable, intelligent women and men who oppose this for very valid reasons, and that's why I would urge a no vote. Thank you.